Our next legal maxim relating to law of tort is volenti non fit injuria, and it is well established rule of common law that if a person himself invites a danger and injury is caused to him, nobody shall be responsible for such injury. Such principle is commonly known as doctrine of volenti non fit injuria. In other words, such injuries shall not constitute a legal injury, and as such it is not actionable. In day-to-day affairs, many such injuries are sustained by people. This particular maxim is nothing but expression of good sense and justice. No principle of law in the world may hold a person responsible for the injury which is outcome of the person's own negligence or effort. Thus, if a person knowingly invites injuries or danger, and danger visits him, consequently suffers for such sufferance, none is responsible. The doctrine further implies that a person who consents to the act being done or takes upon himself the risk of suffering damage cannot bring an action in respect of that act or damage. So is a person who engages himself in boxing, in wrestling matches, or agrees for surgical operation, then if on account of such consent he suffers or an injury is caused to him, he cannot bring any action against the person whom he gives such consent. For the application of this maxim, the following conditions should be fulfilled. First one, consent must be voluntary, and it was decided in the famous leading case I.Imperial Chemicals Industries Ltd. Versus Shatwell in the year 1965. So also in White versus Blackmore in 1972, another English leading case. The second condition, the act must not be itself illegal. So that was decided in Re versus Connie in 1891 in another English leading case. The condition number 3, knowledge of the risk is not the same thing as consent to run the risk, and this was delivered in the famous English leading case Donn versus Hamilton in 1934. This maxim has also certain limitations, such as no consent, no leave or license can legalize an unlawful act. The second limitation, no validity on a breach of statutory duty, which was decided in the famous leading case Wheeler versus New Maton Board Mill Limited. So also the third limitation is relating to all rescue cases, as it was decided in Hines versus Harwood, an English leading case. So also the fourth limitation is relating to cases of negligence, and that was decided in the famous leading case Donn versus Hamilton, another important English leading case. So, from this maxim, we found that if anyone with his own consent invites any danger, then any injury caused to him, then it would not be actionable, and the very maxim Volenti non fit injuria would be applicable in all such cases.